in that series. And this evening I will be speaking about our last wills and testaments. My name is Madelyn Barnard-Smit. I was just saying sometimes I have a little bit of a split personam because Barnard-Smit is my married name that I use in my private capacity, but I actually practice only as Barnard. And then sometimes in certain settings, people will call me Mrs. Smit, and I don't always realize that they're actually speaking to me when they do address me like that. But eventually, I do answer to all three of the names. But so I am a practicing attorney, conveyancer, and notary public here in Somerset West, in my own firm called Barnard-Smit Law. And the Lord has richly blessed us in that undertaking. And so tonight I will just share some of my knowledge with you, and hopefully we can come to an understanding of why this is such an important part of stewardship. So before we get into that and start to unpack some of the thoughts, let's just close our eyes for prayer, and then we can continue. Dear Lord Jesus, we thank you so much that you have brought us safely through another day, and that we can all come together to discuss this important topic. And I pray, dear Lord, that your Spirit will be here this evening, and that you will open our hearts and our thoughts and our minds and our understanding. And may we understand that this is a very important part of our spiritual life as well. And so we pray this, not because of who we are, what we've done, or what we have, but because of who you are and what you have done for us, and because we can have eternal life through you. We pray this in your name. Amen. Okay, so welcome everyone. It's good to see some of you here, those who've just joined us, and also to those online. Welcome to our presentation this evening. Maybe if you enjoy this, you can join us in person next time, or if you are far away, perhaps you can like and subscribe and even share with someone. Okay, so this evening we're going to talk about our wills and testaments. So let's just take a quick survey. Who of you sitting here has a will? Okay. And who has an up-to-date will? Okay. All right. And then of those, maybe if you don't mind me asking, of those who did not raise your hand, would you mind perhaps sharing some of the reasons why you don't have a will? If you want. I don't want to put you on the spot. Okay, so some of the reasons that people sometimes say why they don't have a will is they will say, I'm young. I will think about that when I'm older. And we hear that a lot. But I would like to say this evening that even if you are young, it's important to have a last will and testament. Sometimes, especially if you have minor children, and we'll get to that, it's a really important document to have in place. And I think if there's one thing that we can take away from the COVID pandemic is that anything can happen at any time, regardless of your age, where you are in life. So that's not really a good excuse not to have a will. I'm young. I always say if you have a bank account, you should have a will. Okay. Something else that people sometimes say is, I have nothing. I have nothing, so why should I have a will? I don't have a lot of money. I don't have a lot of assets. So I say again, perhaps I can ask the question, who here has a bank account? Okay, if you raise your hand, you should have a will. And why do I say that? Because when you pass away, that bank account needs to be closed, and the bank will not have your spouse or your child or someone just do it. The bank wants what they call a letters of executorship, and that is a document where a person is appointed by the Master of the High Court to deal with the matters, the estate of the deceased person, and you appoint that person in your will. So if you don't have a will, you don't appoint a person like that, and the administration of trying to close that bank account becomes a process that can take up to 6 months, as opposed to a process that can happen within 3 months, perhaps, if everything works well together. Okay, another reason that people will say that they don't have a will is that they don't have time to go and see someone to make a will. Okay, so I understand that. I'm a busy person too. But I do want to say that, yes, life is busy, but it is almost as important as having your annual health checkups with the doctor. You should have your will in place. And I think apart from the legal and the business reasons for that, as Christians, I think it is part of good stewardship to provide for succession, okay? The Lord has entrusted us with assets and with wealth. And so part of that blessing, I say to my students when I teach, every right has a duty. So rights are not just rights because they are nice to have. The corresponding thing to a right is a duty. So our blessings have duties connected to them. And I think part of that is being responsible with what we do, what happens to our wealth when we are no longer there. All right, so who can make a will? Okay, so any person 16 years and older, if they understand the consequences of the document, they can make a will. So in South Africa, our age of majority is 18 years of age, but this is an exception where you actually have the ability, before you turn 18, you can make a will provided you understand the content. So you can see that, again, I always go back to that thing that I say, if you have a bank account, you need a will. So you can have a bank account at 16 years old, you can open that account without the assistance of your parents, and therefore you can make a will without the assistance of your parents, even at the age of 16 years old. Okay, so there was a very good response when I asked who all has a will. There was a lesser response when I said, do you have an updated will? So why is it important to have an updated will? So a will is a dynamic document. It is something, I don't recommend changing it every Monday morning, of course. That's, it's also not a document that you change as the wind blows. But as circumstances change in life, it's important to update that document. So the will of a single person will look different to the will of a married person. And the will of a childless couple will look very different to a will of a couple with children. And the will of people with minor children will look different to the will of people with adult children. So it's important to update that document as you go through the stages of life and as things in life change. So perhaps one of the beneficiaries that you've named in your will has passed away, then you update that document to reflect that. So I currently, I'm dealing with a matter, an estate that we're trying to wind up. The will was signed in 1992 when the deceased person had minor children. And so the will was drafted appropriately to allow for certain processes that you would do for minor children. But these people are no longer minor children. In fact, they are married with their own minor children at this point in time. But now, because the will was never updated, the only thing that we have to work with is this will from 1992. And now we have to follow the steps as they are set out in the will, even though it's no longer actually appropriate. So it's now causing a huge delay. So to make the process of winding up your estate as smooth and as easy as possible, it's important to have that document updated. Once again, I don't recommend, I have had the situation where, every time this person has a fight with his son, or now the daughter has done something that he didn't like, or this, and then now he comes to me and wants to change his will, and then tomorrow they've made peace again, so he comes and changes it. That's also not ideal. I think last night in Eric's presentation, he quoted to say that, giving should be planned. We should plan and pray about how we give. And I think it's the same with our wills and testaments. To plan and pray about how we leave our legacy. And so I don't think it's something that it shouldn't be like a tree drifting in the wind, but it should be updated as our circumstances change. Okay, so I don't want to belabor the point. I think I've explained that quite well. So now let's move to quickly speak about what does a valid will look like? So a lot of you has actually indicated that you have a will. So let's just talk about what should it look like for it to be valid. Okay, number one, it has to be in writing. If your will is not in writing, so it's not a document, black on white, it's not valid. So Granny sitting there and saying, one day when I die, you should have my brooch from my granny. That's not valid, okay? No one can enforce that, unfortunately. And I find in a lot, when I deal with estates, especially where there was no will, culture plays a big role into that, because there's this expectation of, well, this is what the culture says we should do, but that's not how it works. If you do not have a will, if you die without leaving a will, in South Africa, we have a piece of legislation called the Interstate Succession Act, and that act then tells us what to do with your wealth, okay, with your estate. So when I say estate, that is the collective word that contains your assets, the collection of your assets minus your liabilities and what's left for your beneficiaries to be distributed. So then we have to follow that act. So if you don't want, if you want something specific, then make a will. Otherwise, it's going to be done in terms of the Interstate Succession Act. Now, that act is quite intuitive in the sense that it always looks for the next of kin. So generally, people inherit who you would think would have inherited, but there are things that it does not make provision for. For example, if a person dies without a will and they leave a spouse and children, what is left to be distributed in the estate is distributed to the spouse and the children, and the Act gives us a formula as to how we distribute that. But if your children are minor children, they are not by the law, viewed by the law as being capable of administrating that benefit that they must now receive. So what happens in South Africa is that amount of money then gets paid into what we call the Guardians Fund. It's a government savings fund. It's not a bad investment. The interest rate on it is actually quite good, but the problem is it sits there until your child turns 18. And then they can go and claim that money. So in the meantime, they need schooling, they need clothes, they need food, they need tertiary education, but the funds to provide for that is stuck in the Guardians Fund until they're 18 years old. So that is obviously not an ideal situation. So to avoid that, you make a will and you make an arrangement in the will as to how to deal with that and how to provide for your minor children. So that's an example of, yes, eventually it will get to where you probably would have wanted it to go, but it might not practically be the best solution that we can work towards. Okay, so yes. Sorry, I actually completely interrupted myself, but now that's a good background to work against. So your will needs to be in writing. Now, what is writing? So a typed document or a handwritten document will actually be accepted. But there are challenges with handwritten documents. So a person who wrote a will with their own hand cannot benefit from that will. So if you help your mother to write out a will, you cannot inherit from your mother if you wrote it with your own hand. So when we submit handwritten wills to the Master of the High Court, we get countless queries. We have to then submit evidence that who wrote this document, and that person is then excluded from benefiting from that will. So really the only person that should be writing with their own hand is the person making the will himself, and that person we call the testator or the testatrix. So if the testator wrote with their own hand, that's fine, they will accept that, but if any other person, you can't benefit from that, nor can your spouse. So if you wrote for your mother a will, neither you nor your spouse can benefit from that particular estate. So I would always advise, steer away from handwritten wills and we live in a society where most people have access to computers and things. It's much safer to have a typed document. Okay, number 2, it needs to be signed by the testator. So the person making the will has to sign that document at the end of the document. And if the document goes over more than one page, then each page needs to be signed. Okay, so that is very important. And the other thing that I must just mention is that it is important to keep your will in a safe place, because the master will not accept a copy of it. They only accept the original. So a scanned copy saved somewhere on a hard disk, that's not enough. Even in the age that we live in today, it has to be the original document, okay, signed by the testator. Also, a requirement is that 2 witnesses has to sign with the testator. So who can be a witness? It can be any person 16 years and up. And what is it that they witness? They don't witness, they don't need to know what's in the will, they don't need to know what this person has. I often find this, that people say, no, we'd rather come to your office and your secretaries can sign as witnesses. We don't want auntie so-and-so and person this and that to know what's happening. That is not their business, okay? The thing that the witness is there to witness is your identity. To say that the person who signed this document is the person who signed this document. This is not a forged signature. This is the signature of the testator. That is what they are witnessing. Okay, so do we have to date the will? No, it's not a requirement for a valid will that the will should be dated. However, if you ever wrote another will, that leaves the door open for all sorts of disputes. So it's not a validity requirement, but it does help us to determine, because the will that one would work with would be the newest date, so the last one that you made. So to be able to determine if more than one will is found, we will look at the date. The master will look at the date to decide which will to accept. And so my advice is date your will. Okay, date your will. The interesting example of that is the very well-known composer Beethoven. When he died, they actually found 3 letters that contained content that one could argue that it was a will. And even till this day, there are disputes as to which one of these letters was the actual will and which one was the latest one and which one should have been followed. So to my knowledge, there are actually still some funds of Beethoven sitting somewhere in a fund that couldn't be distributed because there was a dispute about it. I mean, so years and years and years later, you know, so my advice, date your will, okay. So those then the validity requirements for a will. It has to be in writing. It has to be signed by the testator. It has to be signed by 2 witnesses. The witnesses simply witnessing the identity of the testator. Although dating it is not a requirement, I highly recommend dating your will, and then to keep the original safe. And of course, to let someone know where to find it. There's no point in you having a will complying with all these things, and then no one can find it. Because if we can't find it, we can't use it, and then the only thing that we can do is to assume that there was no will and then work with the Intestate Succession Act. So that's also not ideal. And you'd be surprised how many people actually lose their wills. It happens more than you think. Okay, so what should we consider when we are making a will? So I just want to say a word or 2 about estate planning. Simply writing up a will is not estate planning. It's perhaps the first step towards estate planning, seeing an attorney to speak about it, but estate planning is a much wider thing. It's not just writing that will. Or perhaps writing the will is the last step to estate planning, because there are some things that you need to consider before making the will. But estate planning includes things like looking at your wealth and looking at what your death taxes implication would be. And what can we do to minimize death taxes? But then one has to play that off against the costs of moving assets around, because moving assets is not necessarily free. So I had an inquiry the other day about someone who heard about a trust, the idea of a trust, and said, well, now I need to come and see you, we need to register a trust. So I said, okay, fine. What do you want to do with this trust? No, 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 we don't want to pay death taxes when we die. Okay, I understand that, but so what now? We move everything into the trust? Yes, we're going to move everything into the trust. So I said, okay, is the trust going to buy your house, or are you donating it because then you're going to pay donations tax? Are you if you're selling it to the trust, then the trust is going to pay transfer duty, which is also a type of tax. Then you need to look at the value. And will the tax that you pay for moving the asset be less than the death taxes, that type of thing. So estate planning is a little bit more involved than simply saying, I want my children to have my house in equal shares. It's actually considering the cost implications and the tax implications, and also how we move our assets for those purposes. So it can be quite a complicated process, and it's more than just, well, I want my wife to have everything, or I want my children to have in equal parts. It's considering your whole estate. So when people come to see me to do a will, they ask me, what do you need me to bring? And then my question to them is, well, what do you want me to do? Do you want me to simply draft a will, or do you want me to help you look at your estate planning and how what would be the best way to bring down costs in your estate? And perhaps that's just something that I can say a word or two on when making your will and in arranging your assets in such a way that your estate can be wound up fairly easily. The most difficult estates to wind up are estates that are asset rich but cash poor. Okay, so there are lots of assets, but there's very little cash. And the problem with that is that it actually costs money to wind up an estate. Okay? And so if your estate does not have enough cash to pay that, then either assets needs to be liquidated, or your beneficiaries needs to pay money into your estate so that they can retain the asset. Okay, so that is something to consider when making a will, is what is the size of my estate and what would be the cash amount that we would need not to place a burden on your loved ones when you are gone. And there are ways that one can speak about how to provide that cash, something like a life policy that pays into the estate, that would be an option. At death, life policies are not that expensive to pay monthly, but can be a very nice way to provide cash in the estate to provide for the expenses of the estate. So speaking about the expenses of the estate, the next thing to consider is the executor. Okay, so what is an executor? What does the executor do? So the executor is the person that you appoint to deal with your business when you are no longer there. So this person, when someone passes away, the will appoints an executor, and that will be the person that is appointed by the Master of the High Court to deal with your bank account, your cell phone contract, claim your life policies, pay your creditors, transfer the assets as you wished it to be transferred, and to make sure that everything is put into place as it should be, according to your will and in accordance with the law. So this should be a person that you trust, needless to say. And there is a misconception that you can't be an executor and benefit from the estate. That is not true. You can, for example, appoint your surviving spouse as the executor and as the sole beneficiary of the estate. Your spouse just cannot witness your will, because a witness to a will can also not benefit from that estate. So that's the only requirement. You can't be a witness and a beneficiary under that estate, but you can be the executor and a beneficiary under the estate. So the idea there being that there is no conflict of interest, because if you are the executor, you are now on the estate's errand. You're not on your own errand. You have to do things to the best interest of the estate. But if you are a beneficiary, you would also want to do what is best for the estate, because the better job you do, the more money comes your way. That's the thinking. So there's no conflict of interest. So that is why an executor can also be a beneficiary under an estate. And then when we make a will, we have to think about who will be the beneficiaries. Who are we leaving our wealth to? And when we speak about beneficiaries, there are, and I don't want to be too technical about it, but there are two types of beneficiaries. You get the heir, and then you get the legacy. So a legatee, you leave a legacy to a legatee, and that is when you leave a specific asset to someone. So if you say, I would like my wedding ring to go to my daughter, or I leave the house to my son, or whatever. If you leave a specific asset to a specific person, that is called a legacy, and those people get benefited first. So when we wind up the estate, those people first get what they were given in the will, and then the heir. This is the person that gets the residue. So whatever is left goes to the heirs. So because we benefit legacies first, again, so let's say you leave 5,000 Rand to Heidelberg College. Heidelberg College becomes a legacy, and whether there is 5,000 Rand or not, Heidelberg College needs to be paid 5,000 Rand. So it could actually come to a point where your heirs now has to pay money into the estate so that the legacies can be paid. So one must be careful with how you word your will. So a better way to do that would be to say, I would like to leave a percentage of what is available for distribution to such and such an institution or such and such a person, so that you don't get to a point where you're actually creating a burden for your loved ones. Okay. And then lastly, I think something that one must consider when talking about making a will is quite often we make wills in the context of we are married and we want to leave to our surviving spouse. But the unfortunate reality, while it's improbable, it's not impossible, but you can actually die together in the same calamity. And it's important to make provision for that. Once again, especially if you have minor children, because this will be the place where you will, number one, appoint a guardian, who will be the person that will, or couple, you can appoint more than one guardian, who will take care of your children, who will be appointed, you will take over your role as a caregiver and be the person with whom your children will live and grow up with. So to appoint a guardian. And number two, to create a structure whereby your wealth can be distributed to your children in a responsible manner via either the guardian or a trustee that you want to appoint. And this is then here where one would start looking at things like testamentary trusts, which is a trust that one creates in your will. So you don't register a will now, a trust while you are alive now. So you don't have costs of registration now. You don't have to keep the trust running. But when you pass away, there is a way to create a testamentary trust, then to provide for minor children. And that is the way how we get around that terrible situation that I was talking about before, where funds are just lying in the guardian's fund and your children can't access it. So these are some of the things that we need to consider when we sit down to think about what should we put in our will. And this is why I started off by saying the will should be updated as things change in life, because if you are a single person, perhaps you will want to leave to your parents. But if you are a married person, perhaps you want to leave to your spouse. If you have children, perhaps you want to benefit your children, but that may depend, how you structure that may depend on whether they are minor children or are they adult children. Where are they in their life, and so on. If you are a grandparent, perhaps you want to leave to your grandchildren. That's also an option. So when making let me end off by saying this, that this is actually quite a complex topic, and I merely scratched the surface right now. There is no way that I can in 30 or 40 minutes or an hour or even 2 hours tell you everything that you possibly would need to know about making a will. So I highly recommend that when you consider these things, to see a professional who is trained to look at these things and can advise you. And as I said in the beginning, I think that apart from the legal and the business reasons for doing this, as Christians, I think there's a spiritual duty on us to plan for what happens to our wealth when we are no longer there. I think it's just as important as planning for it while you are here, planning, giving, and creating wealth, what happens to it, a responsible way to deal with it once a person has also passed away, in a manner that would be the least traumatic to the loved ones being left behind. So I think for me personally, one of the most important reasons to make a will is actually that you don't want to leave your loved ones with chaos. I think that's one of the worst things that, if you've ever experienced loss of a loved one, it is so traumatic, and dealing with that grief and then having to deal with the administration of an estate that's not in place places such an extra burden on the loved one. So for me, if it's not for a legal reason, or it's not for business purposes, or it's not for a spiritual reason, wherever you are in your walk, then let it be for your loved ones, to leave them with something that is in order and not as traumatic. Okay, questions. What questions are there? I'm happy to take questions at this point. Yes. Yes. If you can just speak into the microphone, then our online audience can also follow the comments and questions. Thank you.
This is just an example that I've experienced some time ago. In my work, there was a two people, a man and a lady, who she wanted to sell a property. And she inherited this from her mother's fiancé, not married, but it was the mother's fiancé. And this gentleman died, and then she had this letter, but it was only signed by one person at the police station. He went to a police station, the policeman signed it, stamped it and everything, but only one signature. We could not get that deal through, because there should be two signatures. And the two signatures, I think you have mentioned it, cannot benefit from this will at all.
Yes.
And he's paid half of the cash in advance to this lady because she needed the money. And I don't know what happened eventually, because they couldn't do the transfer. Yes. Then they found out this man had two brothers, who's next of kin, of course. So I could not meet up with them again to find out what the result was. But it was a chaos.
Yes, so that's why I'm saying sometimes I think it's the first step to making a will is having the intention to make a will. But I think it is important to seek professional advice as to how to do that properly, so that you don't have a situation like that. I cannot tell you the amount of times that people come into my office and then they can't find a will, and then it would usually be the old. In some cultures in South Africa, it seems that the expectation is that the oldest son should inherit the house. And then all the children sit there and they all tell me, yes, our brother should have the house. And then it doesn't work like that. There's a law that we now have to follow. And if that's what your parents wanted, then they should have made a will. And that's it. If you don't want the intestate succession to take effect, then you have to make a will to supersede that. Sonia.
So I just wanted to find out who's the best person or entity or whatever to appoint as an executor, because typically you appoint someone in the family that you trust, because if you appoint a bank or a lawyer, someone that take a percentage of your estate, so that's more money that you need to come up with. But at the same time, I have an understanding for the family member who's now lost someone, and now they have to have that burden of dealing and winding up your estate as well. So what would you recommend?
Okay, so that's a very good question. So let me just say that the law looks at the value of the estate, first of all, and then there are two processes that can be followed. So if the value of the estate is less than 250,000, the master will appoint a family member. And then that's what we call a Section 18.3 estate. and they can wind it up without the assistance of a professional person. If the estate is more, if the value is more than 250,000, you can appoint a family member, but the master will not do that unless a professional person gives support. So whether you appoint, if your estate is above the amount of 250,000 rand, whether you have appointed a family member as the executor or a professional person, you are going to pay the executor's fee in any event, because the master will not appoint an untrained, a legally untrained person to deal with that estate because of what has to happen. And generally, the normal person just don't know. So, but you're a trained chartered accountant, so maybe you do know. But I mean, if I had to ask here, if any of you were to be appointed as an executor, and today the person who appointed you passed away, would you know what to do? Probably not. So how do we deal with that? You appoint your family member, but they are then free at the passing of the family member to engage a professional person to help administer the estate. And at that point, they can negotiate that fee with the professional person. So in the Administration of Estates Act, the fee is set at 3.5% of the value of the assets of the estate. So it's not the assets minus liabilities, it's calculated on the value of the assets, 3.5%, and if they are VAT registered, they are allowed to charge VAT on top of that. But that is the maximum. So that means you can negotiate. That's the maximum. That does not mean that it can't be less. Now let me just say, having said that, obviously the bigger the estate, the easier it is to negotiate, because even people sometimes say to me, but this is a simple estate. Yes, it might be a simple estate, but there are still legislative procedures that has to be followed. Whether you want to or not, if your estate is worth more than 250,000, you have to advertise in the Government Gazette and in a local newspaper that the person has passed away and call upon creditors to bring their claims. Then a liquidation and distribution account has to be drafted. So every single financial institution has to be contacted. We have to write to the banks to say, did this person have an account with you? We have to write to the financial companies to say, did this person have any policies or any savings products or any investment products, any unit trusts? So yes, it might be a simple estate, but there's a lot that needs to happen before we get to, well, here is the money to the beneficiaries. And then once the L&D account has been drafted, it has to go to the Master of the High Court, and they have to approve it. And once it's been approved, it has to be advertised again so that creditors can now say, okay, we see that our claims have been adhered to. So all of that happens in the background that beneficiaries don't know about, and this is the road that we need to walk. Now I'm writing to 4 or 5 banks, which means I have to now wait for them to give me feedback before I can carry on. So there's a lot also that's actually not in the control of the professional person dealing with it. So I know that it sounds like a lot, possibly, but there is also a lot that goes into it. To answer your question, I can't tell you who the best person is. I think it's best to appoint a family member because that is the person that you trust. If you appoint you can appoint an attorney, of course, but again, I would suggest that you appoint someone that you know and trust. If you appoint a company, that's also fine. But the thing with appointing a family member is they can engage a person to assist them, but they would still have insight because they are now the person that the administrator would have to go back to and report to. But if you're appointing just someone that you don't know, then they don't have to report to anyone because they are the executor. So that would be my advice. Okay, are there? Yes. Yes. Yes, you can be both. You can be both. The distinction there is just, as I've explained, legacies gets honored first, and then what's left is divided to the heirs. So that's the difference there. There's another question here. Okay, it seems we have a question from the online stream. Okay, so this is the question that I dread because every estate, every estate is different. So, to a certain extent, how long the estate takes can be dependent on what is in the estate, but not necessarily. It often depends on what is happening at the master's offices at the time. So the first step to winding up an estate is reporting the death to the master. So the master of the High Court that's the official, the judicial body that oversees winding up of estates. So as soon as a person has passed away and you have your death certificate, one reports the death to the master. Now, their official turnaround time that they tell us that it's supposed to take to get a letters of executorship is between 4 and 6 weeks. But I have files on my desk where we have been battling for more than a year to get that letters of executorship. But that depends on what your will looks like. Is it a handwritten will? Do we have to now prove who has written here? Are we getting cooperation from the family members, or are they fighting? Is there a will, or is there no will? Because that also determines how fast we are able to get a letters of executorship. Do we have all the documentation in order? If the deceased person was, for example, married out of community of property with an anti-nuptial contract, we have to submit a copy of the anti-nuptial contract. Now, often the children would come to me and say, well, okay, our last parent is we don't know where to find a copy of the anti-nuptial agreement. So now it takes longer to get, because now we have to find a copy of the anti-nuptial agreement to be able to lodge it for the letters of executorship to be issued. So if provided, okay, let's say this, provided the letters of provided all documents are in order and provided the master's offices are operating optimally as they should, and you get your letters of executorship within the 4 to 6 weeks, now only we can start, because there's nothing we can do until the letters of executorship has been issued. People get frustrated when I say that, but if you think about it from the viewpoint of the deceased estate, what the law does is it tries to protect the assets of the deceased person. So just think about it logically. Why should any person at a bank believe you when you walk into a bank to say, my spouse has died, pay the money to me? Because then, anyone can walk in there with a document. So to protect the deceased estate, they will not do anything. They won't give you any information until a letters of executorship has been issued. And yes, it is frustrating, but I do think it's the best way to do it, because otherwise we do open the door to all sorts of fraudulent things happening. So let me just, and I'm going to answer this question. I cannot tell you. I can't tell you what is the fastest. I think the fastest that I wound up in a estate that was more than 250,000. There was a will, there was fixed property that had to be transferred. Everyone cooperated. Within 4 months we were done. But we received the letters of executorship within 2 weeks, and the L&D was approved within 2 weeks. That's almost unusual. Okay. So that's probably the fastest that I wound up in a state. So the timeline is as follows. You have to report the death, and then you're looking at 4 to 6 weeks for the letters of executorship to be issued. Once that was issued, the Administration of Estates Act gives us 6 months to compile the liquidation and distribution account. What is this? This is an account that indicates the assets in the estate, the liabilities in the estate, and then what is available to be distributed to the beneficiaries, And how is it distributed? Are we liquidating the assets or are we distributing them in asset form? So in other words, are you inheriting a house or are you inheriting money? That's what it comes down to, just as very simply. And then obviously whatever that account says must be done. So if we're liquidating, now we must sell estates, sell property. If there are shares that need to be sold, all those things need to be sold. Now remember, let's just take an example. Let's say the person who passed away had an ABSA check account, a Standard Bank credit card, some shares with Old Mutual, and a life policy with Momentum, and a car with vehicle finance with Westbank, and a house, which is mortgaged still. People come to me and then they say to me, this is a simple estate. Yes, it's not a particularly complicated estate, but now we have to write ABSA for the check account. We have to write Standard Bank for the net bank for the credit card. We have to write Momentum for the life policy. We have to, okay, and so on and so on and so on. All of them need to now respond to us to say, this was the balance of the account at date of death, and here are the requirements if you want it to be paid out into the estate late banking account. And then we have to comply with those requirements. Those requirements include FICA. To FICA a deceased estate is not as easy as giving your ID and proof of address. There is a whole list, as long as my arm, to FICA deceased estates. And then once all of that has been done, the institutions will start paying out the money into the deceased bank account, the estate late bank account. And then with this information that we gather, we compile this liquidation and distribution account. Remember I said we have 6 months to do that. I actually missed a step in between. The latest of executorship is issued. Then we have to advertise the estate for a period of 30 days in terms of Section 29 of the Insolvency Act. So this is an advert that we have to place to say, if there are creditors, now is the time to bring your claim against the estate, because we may not know who all the creditors are. So you can count now. 4 to 6 weeks to begin with, another 30 days over here, another 6 months over here. We are already at almost 8 months. Once we have the liquidation and distribution account, the master now has to approve that account. So this account goes to the master's offices. They look at the will, and they look at the Administration of Deceased Estates Act or the Interstate Succession Act, or whichever acts they all need to look at, and they make sure that what is contained in that account is in accordance with the law and the will and the wishes of the deceased person. Once that account has been approved, it has to be advertised again for 21 working days. Well, 21 days, just days. So that's another month. And only once that time period has elapsed can the estate be distributed, including if there's fixed property that needs to be transferred in the estate to an estate beneficiary. That gets done only at that point. So these are the steps that has to be followed, and there are certain timelines to it. You don't have to take 6 months. You can take 2 months, but the maximum amount of time that you have is 6 months. So again, I dread this question because I just don't know how to answer it. It really depends on how quickly institutions get back to you. And to be honest, sometimes it depends on what's happening on my desk. How busy am I, or can I sit there the whole day and phone up these institutions and chase them up to give me, the information? Sometimes I'm in court, or sometimes, so it depends also. There's a lot of factors that play into it. Okay, I took a long time to answer that question. Was there another question? Yes.
The person that will take care of the children afterwards, but did not necessarily put that in writing in the estate. What happens then?
Okay.
And the second part of the question is, if you want to appoint a guardian that is not a direct family member, so it's not a brother, not a sister, what is the legal impact on that?
Okay, so you do not have to appoint a family member as a guardian. If you appointed someone in your will, generally the law will give effect to that. If you did not necessarily put it in writing, the law will always look for the best interest of the child. So then the Children's Act will come into play. Of course, they will look to family members first. So if there are family members who are willing to take the children and it is stable and healthy, they will generally place them there. So the High Court of the country is the uppermost guardian of every minor child. So even though minor children have parents, not all parents are responsible, so the High Court takes that role. They are the uppermost guardian. So they can even override a parent. So the High Court can then appoint a guardian, but they will always look at the best interests of the child. So they will look at what would be the best situation for the child. And of course, someone familiar, a family member, that would always be the best way to go. Okay?
I would appreciate it if you could guide us to make it simple for our family. Like, what should we compile before we die that is, okay, we'll have these 6 things there, and that's going to help them?
That is a very good question. So I always advise my clients, once they come now to sign their will, we've done all these discussions, the will is done and it's signed. I always say, keep a file and tell someone where to find this file. And you don't actually even need a lot of information in there. The best way to do is to have your original will in there. Plus, if you have just a copy of a bank statement, a copy of, if you have, like I was saying, ABSA, Standard Bank, whatever you have, even if you don't want to put copies of it, you can literally take a piece of paper and just write on there, I have an ABSA check account, I have a Standard Bank credit card, I have a life policy with Momentum, and I have shares with Old Mutual. That already helps us so much. But if we don't have that, and especially in the case of simultaneous death, because usually when there's a surviving spouse, they generally know, they can guide us. But if both people die at the same time, it becomes a lot more difficult. So sometimes what we have to do is then we have to ask the bank for a bank statement so that we can see what the debit orders were against that, and then we can see, okay, this is where we need to go look, or that's where we need to go look. So again, if we know that, for example, again, it's an ABSA account, then we just write to ABSA. But if we don't know, then we have to write ABSA and Standard Bank and First National Bank and Capita, and the whole thing just becomes a lot longer to wind up. Rob, I think you had a question.
My question goes to minor. So if we left something to our grandchildren and they're minors, does it have to go into trust, or can they just get a lump sum put in their bank account?
Okay, so when leaving funds to minors, there are 2 ways of doing it. Number 1 is to create a testamentary trust, to appoint trustees, and to then leave that benefit to the trust for the trustees to administer on behalf of the child and for the benefit of the child. That's one way of doing it. But sometimes the amount of money that you are leaving does not actually just not warrant that. So there is an option to in your will create, to put a clause to say that the funds can be paid to the natural or to the guardian of the child. Usually, so let's just use the grandparent example. So if a grandparent wants to leave funds to a grandchild, we will say in the will that the natural descendant of the testator can take that the funds can be paid to the natural descendant of the testator for the benefit of the children, and that then there are certain things that we need to include in that, but then it gets paid to your child to administer for their child. Yeah. So preference being given to the natural descendant of the testator, meaning not the spouse. Yeah. So you leave to your child to administer for their child. Yeah. That's a way of doing it. So one can do that. The downside of that is obviously there's no oversight. So let's say the person that takes that money, that's given that money, decides to buy a diamond ring with it for themselves. There's no recourse then, yeah. Or very little recourse, let me rather say that. Yeah. Okay.
This is just a question coming up. Say, for instance, an elderly person, just use an example, well in that person's years, have got property for argument, and they've got children with families, and they decide to appoint shall I say, let's say there's 3 or 4 children, that they share whatever properties is, even if it's not 4 different properties, the value of it, they must decide together, we're going to rent it out and take the rent money and share it between the 4 of us, or how many there is. And that is our heritage. And if we should want to eventually sell the property, the one must take the others in consequence. Okay, I can buy out this one, and eventually one ends up with, let's say, the big house or whatever. Can you do that? But now, if this elderly person eventually lives longer than what they thought they would, and they get to a point where they need, let's say, special medical care or attention or whatever, and they cannot afford the old way of living anymore, they've got to go for special treatment, and they do not have the funds anymore. Do you put it in a will that they could, for instance, sell one of the properties or a property, and then whatever is left behind would go to the family in the same way, or what would you do in a case like that?
Okay, so let me just ask you this quickly. So you are saying there is a property that belongs to the parent, let's say, but while the parent is still alive, that gets transferred to 3 or 4 children.
No,
or
not before the time. If you, let's say there's 3 children, and when this elderly person would die, let's say there's 2 houses, for argument's sake. I want to use an equal amount. The 3 children together inherits the 2 houses. Let's say it gets rented out.
Okay,
So that
I'm sorry for interrupting, but I understand now what you are saying. In your will, you left property to children.
That's right.
Or let's say a person leaves property to their children. But before you die, you actually need to sell that to provide for your own care. So, okay. There is no... A will only becomes enforced once the person dies.
Oh, then
so until the time, so it remains your property. You can do with it whatever you want while you are alive. But then just remember, so if you have specifically named that property as a legacy, then one would have to change your will, or that legacy will just fall away. So let's say you have 2 children and 2 properties, and in your will you left one to the one child and one to the other child, and now you sell one. That does not now mean that the other that the children will now automatically share 50-50 in the property that remains. You will have to change your will if that is what you want to do. Otherwise, that will just fall away because that property no longer exists in the estate. Okay. Okay, are there any more questions? There's a question at the back there.
I had an interesting call from my mother the other day who asked me, do I still have my birth certificate? She was very concerned because, she obviously said if I needed my birth certificate when she passes away, that would be difficult, so we have to do it now, so that we can go to Home Affairs if needed. So I just want to check, is that the case?
No. Okay, so I'm trying to think. Okay, so the only time when one would need a birth certificate when a parent has passed away is if someone would come to say that you are not the child of that person. So a birth certificate would be used to prove that. You wouldn't need to have your birth certificate to prove that you can inherit from a will if you were named in that will. No. Then that's on your name and your ID number, and it actually doesn't matter what the relation is. If that will said that, if X's will says that Y must inherit, whatever the relation is or whether there is a relation is actually irrelevant, then that is, unless someone disputes it for some other reason, and then they will have to prove it. So the person who alleges must prove. It wouldn't be for you to prove, Okay. Any other questions? Okay, it seems like everyone is happy and have exhausted. Oh, there's another question.
Sorry, I just remembered. You mentioned wills, writing it in your own hand. Otherwise, it needs to be electronic. So if it's electronic, must it have a signature? Of course, so it's better scanned?
So I did not say that it must be electronic. I said it must be typed. But it has to be a hard copy, physical document, originally signed. Otherwise, it will not be accepted. There has been case law. There was one case where the person, it was a very interesting case. The person left next to his bed where he died a note to say, you can find my will on my computer, it's saved, and then he gave the path to where it was saved in the hard drive. And the master would not accept, so it was printed, it wasn't signed, but it was there, it was printed, it was actually a PDF, so, well, these days it's also not that difficult to amend PDFs, I suppose, but I mean, at the time in this case, PDFs were not that easy to make changes to, but the master wouldn't accept it as a valid will, and it actually went to court. And in that case, the court did allow that will. But it was very specific circumstances. This person was a trained information technology specialist, and his colleagues actually gave testimony to say that no one else had access to that computer and to that hard drive or that file, so it must have been his will. And based on that, and the court was actually very specific in saying that this case should not be used as a blanket now to accept all. The court actually said that. It said this is not the court's discretion to accept or to order a will to be valid must be used very sparingly. The requirements given in the Wills Act, that is what we must follow. And the requirements are, it has to be in writing, and it has to be signed, it has to be a hard copy, and signed by the testator and 2 witnesses. So I did not say electronic. And in fact, a copy, even if you sign it and scan it and then print that out, that will also not be accepted. Not without a fight. The court can declare it valid, but that would have to be on application. And again, you don't want to put your family members through that. You don't want to put your family members to have to go now make an application to High Court to declare your will valid. It's much easier just to comply with what the requirements are, and then we know that there won't be any problems. Yeah. Okay, everyone, thank you so much for attending and for being here and for taking part in the discussion. It's always a lot more interesting for me as well if there are questions and interactions. Otherwise, it's just little me and my own voice here. So it's thank you so much for contributing to the discussion. Yes, perhaps just as a last word, and maybe I should say this to the online audience because I don't know what the reach of this is. I have spoken tonight about the South African law. I cannot speak on any other country's law because I'm not trained in other countries' laws. I'm trained in South African law. So the discussion we had here tonight pertains to South African law, South African wills, and South African estates. All right. Thank you so much. Let's close with a word of prayer. Dear Lord Jesus, we thank you so much for giving us this few moments to discuss this important topic. Thank you so much that we could grapple with these ideas, and may we go away and may you work in our hearts, and may your Holy Spirit convince us of what it is that we have to do, and may we deal responsibly with that which you have entrusted to us. Please protect each one of us as we go our way. We pray all this in your precious name. Amen.